Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. I'm your co-host, Thomas Vick, joined by the other co-host, Seth Wilson. Seth, how are you today?
Thomas, I'm doing great. How about yourself?
Doing well. Busy as ever, but good. Busy is good.
Well, thanks for making time to jump on the call today. It's one of the highlights of the week to just kind of talk through some of the things that we're going through in the practice. And one of the questions that your blog digest brings out today is one that we face very frequently is, do I really need a trust? Is kind of the real question there. The article is titled, Should You Rethink Trust? And I think that is a great way to think about it. And really, I think one of the tools that we face is, can I avoid probate without a trust? And Thomas, like to get your thoughts on that.
You can. The answer to that question is you can avoid probate without a trust. You can do it through a couple different ways. Sometimes people add an adult child to accounts, which is something that we strongly recommend not doing. And then also you can do transfer on death designations. So you could state that, upon your passing, your adult children share equally in a bank account or an investment account. Similar with IRA designations, beneficiary designations. And you can do that with real estate as well. So you can avoid it without a trust, but I'll turn it back to you. What are some issues with merely doing a transfer on death plan?
Well, lawyers like to be as certain as we can be that the plan we're putting in place for someone is actually going to take place. And when you're doing beneficiary designation planning, essentially, yes, that can work. And in some circumstances, maybe the right scenario. And I think the article talked about a couple of those considerations where you're pretty sure things are just going to transpire, or it's a relatively straightforward transfer. The problem is always the unknowns. What's going to happen between the signing of the plan and the actual use of the plan. And having those variables in place make it much more susceptible to change, where you may not have things happen the way you want to without having actually put the title to that asset into a trust. And so one of the things that always comes to mind is the transfer on death deed for real estate is a relatively new addition to Indiana law. And it's a good tool in the right circumstance. But what happens if the law changes? You've got something up there where trusts have been around now, and the body of law relating to trusts are there and time proven, so to speak. You may be susceptible in your older age to scam calls. You see that a lot today. And those kind of things, if the document or the asset is already in a trust, there higher degree of protection there than you might have just in your individual name. And so I think the uncertainty as to the intended outcome is the one thing I always help clients try to navigate and figure out. And again, in the right circumstance, if you're able to beneficiary designate the majority of your estate, you can avoid probate. But we never quite know what that small estate ceiling is going to be, if that's going to change. And so there's a lot of variables there that has to be the right circumstance and very, very fact sensitive.
Yep. All good points. I would add to that the trust, one of those events that you can foresee, but also not foresee is, what happens if a child, a beneficiary were to pass away? What happens with that situation? Transfer on death deed can't deal with that hardly at all. It can to some extent, but a trust can provide a robust plan around events like that, or if a beneficiary becomes disabled prior to an individual receiving their inheritance or whatever it might be. There are provisions that can kind of plan around that, and that's a really cool feature of trust planning as opposed to transfer on death planning. And then on top of that, thus far in our conversation, we've really kind of been talking about revocable trust, but irrevocable trust can be a consideration in thinking, do I need a trust, or do I need to do it a little bit more in a more simplified fashion? An irrevocable trust, some irrevocable trusts can allow some Medicaid planning and get a 5-year look back period running, so that if an individual needs long-term care and needs Medicaid to pay for that long-term care, the trust isn't going, the house or whatever is in the trust isn't going to have to be put up for sale or rent, or the assets used to take care of those long-term care needs. So those are some additional reasons why a trust would be helpful.
Yeah, and I think that's a great point to highlight the distinction between sort of the simplicity and the complexity, because ultimately, as we've talked about many times, the goal of your plan is to provide peace of mind. And so if there are questions or variables that could come into being, a lot of times, from my perspective, that is not a peace of mind, because I'm always going to be wondering if that event is going to occur. Whereas if I can set up a trust that my plan is in place and this is what I know to a legal certainty is going to happen, I can relax about that, knowing that I have that plan in place. And I think the one issue I'd just comment on, just because I've seen an increase in that in our practice this week, are these supplemental needs trust or special needs trusts that can be helpful navigating the specific issues facing families in that scenario. And sometimes that happens as a result of an accident later in life, where there's a traumatic brain injury or something along those lines, and the individual receiving those funds gets a house that could jeopardize those benefits because it's disqualified them. So all good things to kind of think about and make sure that you're addressing. And again, one of the reasons we always try to keep up with our client base on an annualized basis, because we don't know what those changes are going to be and when they're going to occur.
Yes, all good stuff there, Seth. And that sort of leads us into, we talked about an irrevocable trust for long-term care planning. That sort of leads us into the other topic today, and is the cost of a nursing home rising? And the answer is yes, it is. I think by about 2.4